Yes, Mr. Falk.
First of all, on the matter of
Just one moment. I've been given a cookie.
Sitting, yes.
Yep.
Thank you.
Much better.
Thank you.
Thank you.
that will provide at least a partial defence to your claim, my lord.
So sorry.
That will provide at least a partial defence to your claim against the court. Sir.
Exactly. Yes. Yes.
First of all, on a point of housekeeping, I understand that the appellants have been able to locate those witness statements and are getting copies run over along with a full-size transcript. So,
thank you. The former was sent to us electronically. I have skim-read them, knowing my lord and my lady. They probably read them in great detail.
And then I believe we've also had electronically at least the enlarged transcript.
That I haven't had, but
well, I
if
think
that.
it's in the same email. Actually.
Oh, is it?
It's
Oh,
attached.
well, I
It's
failed
further
to print it. Anyway, I can manage. But thank you for whoever did that.
my overarching submission is that this is a quite simple exercise. The judge had ample justification for imposing the conditions that he did. This was the exercise of a discretionary jurisdiction in which he was entitled to take account of the full circumstances and the landscape, including the conduct of all the parties and the factual relationships between them. It's ultimately a question of factual assessment. And if one steps back and considers the very briefest summary of the circumstances which the judge had to consider, in my submission he was fully entitled to conclude as he did. The fundamental substantive allegation was that D2 to D4 had engaged in an asset stripping transaction for the ultimate benefit of D4, Xinbo. Mr. Justice Bright had already concluded on strong grounds that the defence to that was very weak, not least because none of the defendants could explain various documents which appeared to be forged or backdated. The initial strategy on the defendant's side had been that Dynamic and Miss Chu effectively played dead, while Xinbo litigated in Singapore, and I'll come back to that. They only surfaced a year later when a summary judgment application was made against them. What then happened was that Mr. Justice Bright put conditions on the second and third defendants to put up earnest money to show that they were serious in defending claims, partly because of their procedural gameplay and default, and partly, I would suggest mainly, because their substantive defence was very weak. And as I will show you in a moment, he envisaged that Xinbo, which was the ultimate substantive beneficiary of their position, the principal, he envisaged that Xinbo would be the party that would actually be putting up the money for them to meet the condition.
To both. For both.
I think that's right. We'll look at what he says. I think that's right, but certainly in respect of Dynamic. In fact, none of the defendants met the condition. There was then the partial summary judgment application, which, as my learned friend confirmed, was indeed a summary judgment application made on the merits in respect of that point against Dynamic.
Now just one point of order there. That was a decision by Mr. Justice Knowles.
Yes.
I think we have the order. Is there a judgment?
There is a judgment. It's in either the supplemental or unagreed
Maybe because I failed to find
bundle.
it.
The unagreed bundle, tab 12, page 48.
If it's the unagreed bundle, oh, I see. Yes, sorry. Yep.
Thank you.
Speaking for myself, I wouldn't mind just. It's not very long. Just casting my eye over it.
Of course.
So, paragraph 2, when it refers to an application for joining to bring a further party, it is a reference to the Xinbo application which had been issued but wasn't before him. Yep. Yeah, so para 7 addresses explicitly the question of whether it's in default or summary judgment.
Yes, and of course, the court will appreciate the benefits of seeking a summary judgment on the substance rather than a mere default judgment.
Spell them out.
Essentially, for the purposes of enforcement abroad, various jurisdictions draw a distinction between a purely default judgment when a claim is undefended and a decision, even a summary decision of the court on the merits.
Just remember me, the second defendant is dynamic, isn't it?
Yes.
Yes, that is right.
You say that Mr. Justice Knowles gave a judgment on merits, a summary judgment on merits,
Yes.
which Mr. Justice Bright had declined to do.
Mr. Justice Bright had declined to do it on the basis that the second and third defendants were proposing to defend the claim. He had instead imposed conditions on them, saying, well, if you want to run this very weak defence, you need to pay money into court.
Yeah,
They hadn't done that. So the position before Mr. Justice Knowles is that there isn't a defence, but he nevertheless had to be satisfied on the facts that the aspect of the claim on which we were seeking summary judgment, namely return of the shares, was a good one. And in particular, it's paragraphs 10 and following where he reaches that conclusion.
It's the absence of a defence, though, that makes the difference for him, because otherwise I can't quite follow why he was prepared to tread where Mr. Justice Bright declined to tread.
Well, it is. It's the effect, and of course the effect of an absence of defence is that the defendants are then also not able to call witnesses, etc. So it's not merely the fact that there isn't a document setting out the defence, it's that there is no longer going to be, for example, evidence at trial contradicting the claimant's claims.
And does it follows, presumably, well, it's a nice point, but just skipping through it, it doesn't look as though Mr. McCulloch made positive submissions, maybe feeling he couldn't in the absence of a defence. You were there, he was there. No, I'm wrong. There's reference at 12. Sorry, 14, para 14. That's more to reasons why it'd be inexpedient to grant judgment rather than on the substance.
Can we also look at 16, which sort of slightly touches on what would happen next?
Yes.
And also possibly relevant to something that was asked this morning.
Yes, this is a hair that was set running this morning, but in my respectful submission mischaracterises the effect both of this judgment and of the condition imposed by the Deputy Judge in the matter currently under appeal. The effect of this judgment, and Mr. Justice Knowles' order, is that Dynamic is obliged to return to the Luxembourg curator of ETS, that is to say its insolvency office holder, the shares. And the effect of the condition which my client sought and obtained from the Deputy Judge is no more and no less than that Xinbo procure that Dynamic do that. It doesn't follow from that, as appeared to be suggested at one point by Mr. McCulloch, that Xinbo is not then able in these proceedings, subject to complying with the conditions, of course, to argue its position that it is ultimately entitled to have those shares or their proceeds from the Luxembourg curator.
Oh, hang on, wait a minute. These are shares, sorry, remind me, these are shares in...
They're shares in a French listed company called SMCP.
And so what, they would go back to ETS?
Yes.
Without, there's no restriction on what ETS does with them. On the face of it, they're just transferred back to ETS.
They are, but then the question that will be resolved in these proceedings is whether ETS holds them subject to the security that Xinbo claims over them or not.
But
And one can see that from the way the claim is put, which I'll show you in a moment.
What is to stop ETS simply selling them and using the money in the meantime?
Well, the risk the curator would take if she did that is that Xinbo has a proprietary claim against them. It's the same risk that any office holder who holds secured property assumes.
These are listed securities, and they're subject to what security?
Well, our position is that they're not subject to any security.
Right.
Xinbo's case is that there was an agreement called the 2018 Agreement, the veracity of which Mr. Justice Bright doubts in various respects, the effect of which is that there is security over these shares in favour of Xinbo. And that's the essence of Xinbo's defence and Part 20 claim in these proceedings.
So it says there's a security interest.
Yes.
I may have called it a pledge, but I may have got that wrong.
They do call it a pledge, yes.
And so their case, in essence, is that the transfer to Dynamic was by way of enforcement of that security.
A quasi-enforcement, although it's not the purported document on which they rely affecting the transfer purports to be a sale for €1. But that is the essence of what they say.
The substantive point is we're entitled to these shares under the terms of the pledge.
Indeed. And if one looks at their Part 20 claim, which is in the core bundle, tab 8, page 117.
Sorry, same bundle.
Yes, core. No, it's the core bundle.
Core.
Tab 8, 117.
Yeah.
And you see at paragraph 54 what Xinbo seeks by its Part 20 claim. It seeks a declaration that it is entitled to the shares, not a declaration, incidentally, that Dynamic is entitled to the shares. And it seeks an order that ETS, or alternatively Dynamic, as appropriate, transfer the unpledged shares to Xinbo. So Xinbo's assertion of rights is, quite logically with respect, premised on the contention that it is ETS, which of course originally held the shares until they were spirited away to Dynamic. It is ETS which holds those shares, they say, subject to security in favour of Xinbo.
And is this, I mean, so is it understood or common ground or in some way understood that the position that Xinbo is maintaining would be preserved if the shares are transferred to ETS? I mean, it's slightly odd that the shares seem to be transferred to ETS without restriction. I mean, you may be right that it's the office holder may be taking a risk if they do something with them, but there's no provision to protect anybody's rights. There's no condition or no protection of anybody's rights in relation to the shares in the hands of ETS.
It's true, I suppose, that the Luxembourg office holder has not given an undertaking to the court. There's no injunction against the Luxembourg office holder. But isn't that respectfully simply the position in any normal insolvency? The office holder comes in, they take over the property of the company. If there is a dispute about whether some of that property is the subject of a pledge, the expectation is that they will hold on with it, or if they deal with it, they will deal only to the extent they're legally permitted. And that legal dispute has to be resolved.
Yes, I mean, but when Mr. Justice Knowles ordered the shares to be transferred by Dynamic to ETS, you say he didn't do so simply because of the default in providing a defence. He did so on a consideration of the substance. I'm trying to understand why he didn't also deal with basis on which that transfer back should take place.
If you go back
He
to his
contemplate- Mm.
judgment in 16,
16.
he seems to contemplate that something else might then happen. That doesn't go further than that.
That's exactly what
And
he
he
does.
doesn't, just addressing my lord's point, he's not saying anything here about the failure to file a defence. He's not overtly linking it to a failure to file a defence.
No, and that's consistent with what he says at paragraph 11, which is that the matter before him is one between the claimant and the second defendant, to look dynamic. And it's for a transfer back of the unpledged shares. So the effect of the Knowles decision is a decision which I'm not sure is really controversial between any of us, that Dynamic doesn't have any entitlement to the shares. The shares must come back to ETS, which is where they sat in the first place, in the person of its curator. And then, as he describes at 16, any issue about the ownership or entitlement of those shares, whether under the pledge or otherwise, is a matter for the other parties who assert rights in them, to which Xinbo, the other creditors, and potentially the curator.
And the declarations that were sought were declarations as to beneficial ownership.
Paragraph 11.
Yes, I'm just seeing if we've got his order, which would set out what they were.
But it's not the order, it's the application that would show what declarations you were seeking. Isn't it?
I think his order doesn't go to
Looking to see if we have either of those documents.
We don't have the.
No, we do. So we do have his order,
Yes.
which is in tab 10, the supplemental bundle. Sorry, tab 3 open at once.
Do you mean tab 10?
Yes, tab 10 of the supplemental,
Oh, yes, of
which
course.
is the
Sorry.
same as
Yes,
neither
yes,
the
yes,
core
yes.
nor the unagreed.
Oh no, sorry, I'm being slow. Give me a moment. So if we look at the recitals, the recital were relevant. It's the fourth recital. No.
Yes,
Yes?
yes,
On the application trustee pursuant to CPR 24.2, so that's summary judgment, and CPR 12.1, that's default judgment, presumably. For judgment.
yes. So we applied for default judgment in the alternative.
Yes, no, I see that.
Said if you weren't satisfied on
No.
the facts, you should give us default anyway.
No, quite. But it doesn't say what. I suppose you could go back. In theory, you would be asking for the declarations which appeared in the pleading, but that might or might.
Indeed, but we didn't. Those don't appear as part of this order. What does appear as the order is paragraph 3,
Yeah, no.
summary judgment in favour of the trustee on its claims for the return,
Yes.
and then the order is in paragraph 4 that they shall be returned to the curator's account,
So the,
and then the question of further relief is reserved.
so the declarations that you were seeking in your pleading, which I assume are the ones he said he wasn't prepared to grant, was that the unpledged shares remain the property of ETS, and the title to the unpledged shares continues to belong to ETS. Council therefore asks the court to declare that the unpledged shares remain the property of ETS.
Yes.
So, in other words, what he was saying is, well, I'm not prepared to say today that as to who owns the shares, but I will just order them to be transferred back to where they came from. And there's no further provision made as to what's to be done with them, on the basis that they will just come out in the wash. Or it'll be something that the curator, or whatever it's called, of ETS will take on board.
Exactly.
Sorry, do we have written down anywhere? I think I'm probably behind my order what those declarations were.
I think it's the closest we get is probably at page 82 of the core bundle.
Yeah.
In paragraph 36B of the particulars of claim.
Yes.
And that's followed through into the prayer for relief, which refers back to 36B. And that's the only declaration that I've seen anywhere.
But that all makes perfect sense. The application might or might not have spelled out what the declarations were, but it would be enough for it to have asked for summary judgment in accordance with the particulars of claim.
Indeed.
Yeah.
So he's saying summary judgment on the retransfer back to ETS.
Exactly. So they are then retransferred, and as his paragraph 16 makes clear, paragraph 16 of his judgment.
I mean, it is slightly weird because if you look at the prayer for relief at page 88, it says you want a declaration in the terms pleaded at paragraph 36B, which we've just looked at, alternatively paragraph 36C, and an order that the second defendant return the unpledged shares to the ownership of the first defendant in the first defendant's custody account at BNPSS.
Yes, but that's not the wording that the order uses. No. The order is narrower than that, and I would suggest deliberately so, because the distinction that is made by Mr. Justice Knowles is a distinction between deciding that Dynamic doesn't have any interest in these shares and has to reverse the transfer and give them back. So the sale for €1 did not actually happen. And the secondary question, which he doesn't decide of, once they are then given back to ETS whence they came, who has what rights in them thereafter? So that's the order that he made. And really, for the Deputy Judge's purposes, the significance of that order was actually quite straightforward, which was that there was an order that Dynamic had to give the shares back, and it hadn't done so. So that was the position in the Knowles order. In parallel to that, you had Dynamic proposing to join Xinbo. What then happened was that Xinbo was joined, there was an agreed date for its defence, but it left its lawyers without instructions and didn't file. The other relevant, or the other particularly relevant circumstance before the judge, and this wasn't really touched on this morning, but we'll need to come back to it briefly, was that Xinbo had also been pursuing proceedings in Singapore in respect of these shares, which had been struck out for its failure to make proper disclosure, and also that it had previously commenced proceedings in England, which it had then not served and decided to go in Singapore instead.
So I picked that up. But
I'll come back to that
right.
in a moment. But just to finish my summary of where I say the judge was, one can ask the question posed by my Lord Justice Underhill this morning: if this had arisen, for example, in the context of a Part 24 application, could the judge properly have made this order? Could he have made an order to pay money into court and to let the office holder have the shares back, subject to the fact that if those conditions were then met, Xinbo would be entitled to argue in the English court about its entitlements? That's actually the question he had to answer. And in my submission, he was entitled to answer it in the way that he did.
And was Xinbo's pending joinder before Mr. Justice Knowles at this stage? Presumably it had been sought, hadn't it?
Yes,
Yes,
it was.
he
makes
he
express
mentions
reference.
explicitly that that it happened, but it wasn't before him. There'd been an earlier case management decision that it wouldn't be listed on that day. Is that right? Or I miss?
Indeed, and if one looks towards the end of paragraph 16, he says, I am conscious that Xinbo may be coming into the proceedings. That question has yet to be determined.
Yes, it's para 3 I had in mind.
Yes.
Those
so-
applications, joinder and removal, are not before the court. Indeed, the court by previous decisions refused to allow them to be listed today.
Yes, and what he says in 16 is, of course, I think at least a partial answer to the puzzlement of my Lord Justice Snowden about, well, what does Mr. Justice Knowles have in mind here? I think one of the things he has in mind is that there is this application to join Xinbo, and that may well then be the context for the fight as to who really has the ownership interest in these shares.
You're probably right. Though, to be fair, if we were taking you entirely literally, there may be arguments from one or more of the parties before the court today. That didn't include Xinbo, but
No, it did include its solicitors and
yeah,
counsel
but
and
still, then I see the force of your point.
So my submission is going to be that the judge was entitled to have regard to all those circumstances in making the order that he did, including the admissions, which I will take you to, and findings, which I will take you to, of control by Xinbo of Dynamic and the nomineeship relationship, specifically in relation to this litigation. And he was entitled to form the view that Xinbo, as principal, bore at least some responsibility for Dynamic's prior conduct, and that that prior conduct had a bearing on whether Xinbo should be required to put up earnest money, and whether it should be required to procure that its subsidiary comply with the order of the court, that the shares should be sitting in the hands of the curator and not in the hands of Dynamic. And that, in my submission, doesn't require the court to go down the route of piercing the corporate veil or even attribution or any of those technical concepts. It is actually a part of the discretionary factual assessment that the judge was entitled to and did undertake.
Not attribution in any formal sense, I see, but in fairness sense, it must involve a view that Xinbo took some responsibility for, with a small r, the conduct of Dynamic.
Exactly.
Yeah, I mean, there must be some basis. There must be some basis to connect
Yes.
Xinbo with Dynamic's previous conduct in relation to the litigation or otherwise to justify imposing, on the face of it, a swinging order on a newcomer, other than which all it had done is been a month late with its defence. I mean,
absolutely.
So I know you say you don't need to go into technical stuff like company law, but there needs to be some connection, call it what you will, some legal connection. Whether it's attribution, agency, nomineeship, piercing the corporate veil, or something. You need to have some way of connecting the two, do you not?
You do, and the two factors here, which are exactly the same sorts of factors as you see in areas like the Reed-Barthampton jurisdiction or security for costs and such.
Sorry, what was the first the first jurisdiction you referred to?
Rebarthampton, which is the
Oh.
line of company cases to do with liability of a director for the costs of causing the company to defend proceedings
Yes, I see.
effectively in his own economic interests.
Yeah.
And one also sees it in, for example, security for costs, third-party costs orders, and so on.
Yes, I was thinking possibly aid and shipping. Is that, and would that be a relevant, a similar line of?
Yes, and also the authorities to do with litigation funders and so on. These are questions which quite commonly arise in procedural questions that the court has to ask itself. And in my submission, the common touchstones that the court finds itself looking at in those circumstances are: one, did the party have control over the litigation? And secondly, in whose substantive interest is the litigation being fought?
Those are the two factors you've just referred to.
Exactly. Those I would submit are the two factors that the judge could, and I would submit did, sensibly have regard to here. I would put a little bit of flesh on those bones factually, but I think you can immediately see where I'm going with them. Where there's a relationship of nomineeship, the interest in the shares is always said to be ultimately Xinbo's rather than dynamic.
So you say the nomineeship really answers the second question definitively?
Yes. And the combination of nomineeship and the evidence and the findings, which I'll take you to, about who was funding the proceedings, who was providing the evidence, etc., also takes you to control.
Yeah.
To be fair, the exercise you're taking us through at the moment is not, doesn't jump out of the page on the judge's judgment.
Well, I think if one looks, and we'll have to briefly, at his judgment, he talks about the corporate points, and he describes, I think he calls it an air of surreality. All of these facts were before him, and in my respectful submission, when you look at them all as he did, I think it would be fair to say that there is an air of surreality, both in terms of any suggestion that there wasn't control, or that the real interest in the litigation was not that of Xinbo.
But if we come into it as we did earlier this morning, I mean, there is a question about whether the judge's judgment, in a sense, showed his working.
Mm-hmm.
And then there's the question of what his working actually might have been, or what this court's working would be if we decided we had to make the judgment again. I think it's on the latter you're really about to take. It's the latter course you're really about to take us on, I suspect.
That is the course I'm about to take you on, but I'm going to do so by way of a brief detour to the authority on reasons.
Yes, I mean, if, not particularly encouraging you to do, but speaking myself, I haven't made up my mind whether the reasons can, as it were, be saved, or whether we've got to do this ourselves, or whether we've merely got to find out what the reasons were from the various hints in the judgment and then say whether they're all right or not. If we are going to go down the latter course of finding out what the reasons were, I strongly suspect, I know because I've read your submissions below, that much of what you're going to be saying to us is actually to be found in your submissions below. Chunks of which you simply recycled, I don't mean that rudely, in your skeleton here. But that's right, isn't it? I mean, the judge refers to your submissions below specifically for the key findings of fact which he's proceeding on and of procedural history. He doesn't refer to your submissions below explicitly for what reasons he draws from that. But if one was being charitable, one could say that where he refers to the transcript, he's referring to your oral submissions, which are in turn based in your certain argument.
Yes.
There may not be a lost cause to defend his reasons, though I don't think we'll ever say anything very complimentary about them. Anyway, there we are. I just didn't want you to assume that we were necessarily simply going to say these reasons are not good enough and we have to proceed to the substantive issues for ourselves.
Indeed, I don't need to take much time with the reasons, but I do make the submission that they are adequate. And my Lord put it in terms of being charitable. in my submission, that sort of lens is the lens which the authorities invite. And the one I think I should take you to is tab 2 of the authorities bundle, which is the English and Emery Reinbold authority. And it's really from paragraph 16 in particular, which is on page 106.
Yeah.
And perhaps if you were to read paragraphs 16 to 19 to yourselves.
It's more on the substance, it's more 17, isn't it? 18 and 19 are on a separate point, aren't they? Really, they're more about what to do when the reasons are said to have been inadequate.
Yes, 19 does also though make the point that not every factor which weighed with the judge in the appraisal of the evidence has to be identified and explained.
Yeah.
So that's an important point I would take.
But anyway,
but I agree. If one looks at the judgment and asks oneself, why did my client win and Mr. McCullough's client lose? In my submission, one can discern that from the judgment. One can understand the purposes for which the condition is being imposed to ensure the dignity of the court, i.e. that its orders are respected and that the defence is either being made in earnest or it's not. One can discern from it the two central reasons why that was said to be so, which were the two same central reasons of Mr. Justice Bright, namely the fact pattern, i.e. the underlying strength of the claim, and the behavioural profile, which is a shorthand for the various procedural defaults which we are addressing. So if one asks oneself the question, can you see why the result was as it was, then in my submission the reasons are adequate. And it's important to remember...
But that would be inadequate. If it stopped there, you just described it, I'm not sure that would be adequate, because all that relates to dynamics, previous involvement you haven't made, and I don't really understand why or how the judge made the connection, described the connecting factor to Xinbo, other than his surreality comment. Surreality in terms of corporate reality behind the scene. I mean, it's just different. And I'm not just being an Iraqi company lawyer here. I mean, this is just, it just doesn't mean anything, does it?
Well, in my submission, it does. I mean, in the end,
it's the sort of thing you might say down the pub, but I'm not sure it's the sort of thing you should say in a.
In my submission, it's the last part of paragraph 2 that is the real point here. The judge says, I express, and I think I'm free to express, some scepticism about some of the technicality that I've heard in terms of invocation of separate corporate personality and absence of de facto control. And in my submission, what he's touching on there is the fundamental points that I'm making. First of all, there is control. He's entitled to find that there's control. There's ample evidence of it. In fact,
sorry, when you say control, do you mean, as I think you said a moment ago, control of the litigation? Or are you referring to more than that?
I in fact mean both, and they're both relevant for different purposes. So, for the purposes of responsibility for prior procedural non-compliance, the principally relevant thing is going to be control of litigation. In relation to the distinct points taken about ability to comply with the condition, i.e. can Xinbo procure the retransfer of the shares, there it's going to be control ultimately of the shares and the nominee relationship.
But he's talking about he just says, I'm free to express some scepticism. I mean, he's not making any determination in favour of it. And then he calls it the technicality that I've heard. I mean, if you were talking about the control of the litigation, I don't understand why he'd use the expression technicality. I mean, I thought what he was talking about here was in fact related to the corporate structure. And he was basically saying, oh, come on, it's all one part of one corporate structure. You know, it's a subsidiary, so you know, don't get company law technical on me. But I mean, this is the problem. I just don't really, since we're on the way in which the reasons are expressed, I'm really not sure I do understand or get quite the same thought that you seek to get out of that, because it's at very least ambiguous. And what English and Emery-Reinbold says that should happen is the issues, the resolution of which were vital to the judge's conclusion should be identified, and the manner in which he resolved them explained. Well, I'm struggling at the moment to understand how that requirement from paragraph 19 is met by paragraph 2 of the judge's judgment in any sort of adequate way.
Yeah.
Well, I think if one reads only paragraph 2 and one doesn't read any of the submissions or the evidence, I see.
I think your line has to be, and I think is, that I think there are dicta, if it's not in English and Emery, it's in one of the other leading cases, that you should understand the judge's judgment in the light of the submissions made of which the parties will have been aware, something like that. And you can't get home on the judgment itself. You've really got to say that it must be understood in the light of what the defendants will have known about your case from your written and oral submissions, and indeed the previous judgments.
Exactly, and
that may or may not be good enough.
Indeed,
I've just been looking again at your skeleton below, and you do address the question of what the link is, between effectively why Xinbo should be held liable for dynamics conduct, and effectively your phrase you use is as controller of its subsidiary and nominee.
Indeed.
But anyway, it's been helpful to clarify that, but I think we want to get on as soon as we can with the substantive points that you're going to make about why and in what sense Xinbo had control, whether we're looking at company law control, which is fairly straightforward, or its position as principal in regard to the shares, or the other somewhat broader factors you've referred to about the control of the litigation, which is based on factual question about evidence and costs.
Yes, and I shall come straight to those points now. As my Lord Justice Underhill identified, my skeleton below identified a number of points. This is the supplemental bundle, tab 23.
Yes.
And perhaps we can start there, although there are some references that I would have to go to. This is really all in support of the point that there was much material before the judge, and I simply want to highlight some parts of it. So if one starts at page 142,
yeah.
So paragraph 3 identified the key background, including the judgment of Mr. Justice Bright and the 3 relevant witness statements of Mr. Yardley. There was then some background that we don't need to look at, but if you look at subparagraph G over the page on 143, I identified there the 4 key points which had been identified by Mr. Justice Bright as fundamentally undermining the account that was advanced. And as I then pointed out at H, the defendants had actually made further contradictory statements since that date. And I picked that up at paragraph 18 on page 150.
Yeah.
In terms of them being struck out in Singapore. And so the judge had those things in mind. And Mr. McCullough says, well, if this had been put as a summary judgment application, I would have argued it differently, or they might have said something different. But the reality is, there isn't anything they've ever said or seemingly can say that are answers to Mr. Justice Bright's points, and they were a year on and they failed to do that. I then at paragraph 5. So
without slowing you down too much, it would be legitimate for us, I suppose, the answer to that, to see the extent to which these points are made, perhaps not in the same words, but in the witness statement in support of the application for conditions, which is presumably by Mr. Yardley, isn't it?
Yes, that's.
Yes, well, I'm not asking to be taken to it now, but
No.
we might look at that if we had to.
Yes.
Okay, but this is the material before the judge.
Exactly, and then in paragraph 5, he was given a history of the proceedings, the non-compliance with conditions, the attempts to appeal, and so on. Then in paragraph 6, I picked up the points which I trailed earlier on, which I don't think my lords had heard about, at least the English proceedings, this morning. And that was that Xinbo, back in 2023, had issued proceedings in England seeking recognition or registration of its arbitration award, but had then never served them. And then, as you are aware, it then went off to Singapore and its application was struck out, and that was affirmed on appeal. So those points, which were expressly referred to in argument, it's internal pages 10 and 13 of the transcript for your note, but I don't think we need to go there. Those are points about Xinbo's own conduct, which in my submission were also highly relevant in terms of the playing ducks and drakes and pursuing different proceedings at different times, which were before the judge. And so you've got at least 3 aspects of Xinbo's own procedural conduct before you even get to the question of dynamic. It's not just coming in and then being late with its defence, it's also the conduct in Singapore being struck out for failure to disclose. And it's also having started those prior English proceedings and then not pursued them, only to pop up in England again very much later in time. And those points are also illustrative of the link between the conduct of Xinbo and the conduct of the other defendants here. This all has to be viewed as part of one wider picture where matters are pursued in Singapore, neglected in England. Then Dynamic picks them up again in England, only to then not satisfy the condition. Then Xinbo comes to try and pick them up again in England, but then doesn't file its defence in time. And so one sees the going back and forth and the relationship between all of those things.
So you're saying it's only after the Singapore proceedings failed that there was re-engagement in England? I think that's the
those 2 things happen very close in time. So the Singapore proceedings are struck out on the 25th of July 2024.
Yes, that was my point.
And if you can compare the timeline.
And it's curious that paragraph 6, the reference to Singapore proceedings and the unserved English proceedings is in paragraph 6, which is one paragraph the judge doesn't actually refer to.
Doesn't explicitly incorporate by reference, yes.
In fact, I mean, he refers to the 2 preceding ones, but not that one.
Yes, one suspects that he picks those out because they are the sort of the bulky paragraphs, as it were.
Well, yes, it may be a bit more than that. Those are the paragraphs which set out a short summary of the facts and a short summary of the history of these proceedings. And though that's natural for him to refer to those in particular,
Yes.
it's unfortunate if he doesn't expressly refer to any of the other matters, but you can see why he chose those ones.
That's a much better way of saying what I was trying to say, yes.
Well, it wasn't just that they were longer, it's my point, yes.
No, it's something to do with what was in them, yes. On page 153, one can explore a little bit more about the timing and sequencing of the joinder position. So you see the summary that's given there at 24 B to E. And perhaps I could just invite you to read that to yourself.
Sorry, I missed the reference.
It's page 153 of the supplemental.
And 25.
Yes, exactly. So 24 is the principal point here.
Yes, thank you.
So you see that even there they were being ambivalent about whether they were to participate. One gets the quote from the from what Dynamic itself said at page 102 of this bundle.
Well, this is the reference for what, for D?
This is the reference for D, yes, in particular. So it's paragraph 34, page 102.
Yes, thank you. Yep.
So that was where one had got to in terms of the background. So I'm now going to deal, and I can do this briefly because we've covered quite a lot of it already, with the essential points about the relationship between Xinbo and Dynamic. And the first point is the nominee arrangement. And in my submission, there are two particular and specific things which flow from that arrangement. The first is that where Xinbo is the principal and Dynamic is the agent, Dynamic is required to follow the directions of Xinbo in relation to the shares. And it follows from that that, at least for the purposes of what we're looking at, the actions of Dynamic in relation to the shares and the litigation about the shares can be properly attributed to the direction of Xinbo.
It doesn't necessarily follow. I mean, it's true that Dynamic, if told to do something by Xinbo, Xinbo ought to do it. It doesn't follow that Xinbo did direct Dynamic to do everything that Dynamic did.
It doesn't necessarily, as a matter of fact, follow, I agree, but in circumstances where Dynamic is Xinbo's nominee, Xinbo can therefore give direction.
Yeah.
Dynamic does things.
Yeah.
Xinbo doesn't say, I didn't tell Dynamic not to do
As part of a building block,
Yes.
as a building block in, I suspect you're about to get
Yes.
to, I understand the proposition that Dynamic is supposed to do what it's told by Xinbo.
Yes.
But if you're saying that's it, end of story, just this point, which I thought I heard, I sort of sensed you were saying this really is, then it doesn't prove your point. You need to add it to the other bits, don't you?
You're really saying on this that what Dynamic having been ordered to transfer the shares, what's missing is the instruction from Xinbo to Dynamic to comply with the order.
Indeed, in terms of compliance with the Knowles
You
jail.
can see from Dynamic's point of view, if it is a true nominee, it's going to look to Xinbo to direct it whether to comply.
Yes, indeed, and we'll come to the factual points about control in a moment, because my Lord Lord Justice Snowden is right that I don't have to stand on this point alone. My submission would actually be that if there were nothing more, the logical inference of the court should be that the nominee is following the instructions of the principal.
Well, that's
but I don't need to stand on that.
That's why I picked you up, because that's what I thought you were effectively hinting at. But anyway,
yes.
You need to get on with the rest of it as well.
And the other thing that flows from the nominee arrangement is the interest and benefit point, which is highly relevant here, because the effect of that arrangement is that the whole of the economic interest in the shares is an interest of Xinbo and not Dynamic. And therefore the litigation, at least as regards the retransfer of the shares, to the extent Dynamic was defending that, it was being done solely for Xinbo's own benefit. Dynamic had no independent interest in retaining the shares, because its own position was that it had to give over the entire benefit to Xinbo. One then gets to the prior findings and admissions of control, and the best place to start here is Mr. Justice Bright's judgment, which is in the supplemental bundle. Tab, page 37, which is behind tab 4.
Sorry. Which tab? 37.
Tab 4, page 37.
Yep. Which paragraph in particular?
Paragraph 10.4 in particular. So paragraph 10 as a whole describes the historical arrangements in relation to Dynamic, which was originally operated by Ms. Chu. But it's 10.4 which is really key. So Mr. Justice Bright's finding was that there was at least an appearance of ultimate control. Points out that the evidence on behalf of Dynamic actually came from Xinbo.
Yes.
He says there that the sole director remains Ms. Chu's company. That's no longer the case. Our understanding, which is, I think, in Yardley 10, but I don't have the reference in front of me, is that the sole director is now an executive of the Ruyi Group, which is the ultimate majority shareholder in Xinbo.
I mean, the difficulty with all this stuff is, what does he mean by ultimate control? Does he mean just in the corporate Companies Act? More than 50%, or some other technical? What does he mean? I mean, if you're going to say that the litigation was funded and dictated by Xinbo, by Dynamic's participation in litigation was supported, run by Xinbo as a matter of factual control, then I understand that submission. If you're sort of just looking at it in the purely corporate sense of control, we both know that control is a slightly slippery concept in company law terms.
Yes.
I mean, and this seems to sort of mix the two. One is he says Pearl transfers its shareholding. Xinbo appears to have ultimate control over dynamics since that date, with the result that, and then he goes on about who's been providing evidence and the like. Is he talking about control over activities as a matter of fact, or
Well, it's clear that what he's talking about is at least activities in relation to the conduct of this litigation in relation to the shares, which in my submission is all that actually matters here. And then the other paragraph of his judgment that is relevant, or particular relevance, is paragraph 129, which is on page 57, which is about where they would get the money to satisfy the conditions.
Ms. Zhang is of Xinbo, is she?
Yes, so her evidence was adduced by Dynamic, but she is the Deputy General Manager of Xinbo. That was what we saw at 10.4.
sorry, I must have misheard your reference. I thought he said 129.
9.
129.
Sorry.
Yeah.
So that tells us that Xinbo is funding the entirety of the litigation, and Mr. Justice Bright's view was that Xinbo could and would make the necessary funds available. Square brackets, he doesn't say this, but if it wanted to. And so that reflects, going back to my two indicia, that the funding goes directly to control of the litigation. And the point about, well, who is it anticipated will put up the money, goes to the question of in whose interests is this litigation really being conducted. And then further in terms of control, Mr. Yardley in his evidence, which is in the unagreed bundle, I'm sorry to dot around like this, but it's the unagreed bundle, tab 17, page 171.
Which paragraph did you say?
It's paragraph 38. Mr. Yardley cites various statements made by Xinbo witnesses called by Dynamic about what the relationship is.
Yeah. Have we got those?
Do we have all the underlying citations? I'm not sure we do in this bundle, but those are the quotes which reflect the way the position has been held out on their side of the fence. And so I say that the totality of that shows you that Xinbo has control at least of these proceedings and the affairs of Dynamic in relation to the shares. It funds, it provides the witness evidence. There are shared solicitors and counsel.
So this is a witness statement of
This is a witness statement of Mr. Yardley
on behalf of.
on behalf of my client,
But quoting from witness statements.
previous evidence, which you see footnoted, of Ms. Sigurdsson, who is the solicitor from AES, who act for both Dynamic and Xinbo.
Yeah, what I'm struggling with is, I mean, these quotes sort of have the same problem of being out of context. It says, regardless of the structure through which Xinbo holds Dynamic, that seems to suggest that what follows has no reference to shareholdings or anything else. And then he pulls out a lot of quotes that seem to relate entirely to, or certainly one relates to shareholding, 2 relates to shareholding, 3 is I'm uncertain about, 4 could be in relation, could be shareholding or not, and 5 we know. So I'm just out of context, I'm struggling to understand that these support the proposition, which I do understand you're making, which is that the control of the litigation is in the hands of Xinbo as principal on whose behalf the litigation is being conducted by Dynamic. I mean, these seem to be quotes that relate to some other sense of control.
Well, indeed, but I mean, we can probably get Yu Zhang 1 to look more at the context, but these are not Companies Act proceedings. This is not a case in which the parties are disputing the Takeover Code definition of control or the Companies Act definition of control. This debate is conducted entirely in the context of these transactions and
this is why this morning, I mean, I'm not, this is why this morning, I understand you entirely the point. You say, look, everybody accepts that Xinbo, the relationship between Xinbo and Dynamic is one of principal and nominee. And you say, therefore, it stands to reason that Dynamic's behaviour in this litigation would only be being done for the benefit of the person actually interested in the shares, Xinbo, and indeed it would have to be funded and supported in the litigation by Xinbo. And you may, I think, point to the fact that they have had at some point common solicitors, if they don't still have, but they may have had common solicitors or whatever.
Yeah.
Are you focusing on the principal nominee relationship and the control of the litigation? That I find all entirely understandable. What I find not as comprehensible or as helpful is people focusing on the shareholders and control referable to shareholdings, which this seems to be done. So I'm just not sure this takes your main thrust of control of the litigation any further.
Well, I mean, you understand my principal submission, which is that I don't need any of this because of what I've already got on control of the litigation. But in my submission, it is all relevant grist to the mill, because when one is looking at control of the litigation, who controls the company, who the director is, etc., those are all relevant factors.
But there's also, as I understand it, because Justice Bright, rightly or wrongly, clearly did not regard it as necessary to be very specific about what he meant by control. You, I think, would say rightly, but he didn't. But he has made that finding. You have relied on that finding and on the material supporting it. I don't think there's any contrary evidence saying, well, control, look at these rather arcane arrangements, we may have these shares, but we don't have these voting rights, or whatever it may be. There's no contrary evidence that the control referred to isn't both legal and factual. Or am I, you, if you don't tell me, Mr. McCulloch will, but I'm pretty sure, we would have been told, that there's no evidence anywhere saying we don't really have the control that it looks as if we have.
Yes, I think the essence of that is right. There are, Mr. McCulloch seeks to...
Mr. McCulloch does make various points at a level of generality about we only have 51% and we don't know what BVI company law is and so on. But those are not based on specific assertions in the evidence that they don't have control. They're merely saying, well, we don't know what might happen.
Well,
I don't mean to be unkind to Mr. McCulloch, but I'm pretty sure he didn't go any further than that.
No, you would be, in my respectful submission, right about the ultimate substantive content of what is said. I mean, for example, on ability to comply, which is not quite the same thing, but is very close, at paragraph 48 of the skeleton, what's said is, it is and was at the time of the hearing before the deputy judge unclear whether Xinbo could comply with such an order. And then the various points are made about the bank mandate and all of that sort of thing. But I haven't taken you, and I might have to very briefly, to the Garma authority, but that's clear that the burden on someone who's saying they couldn't comply with the condition...
Yeah, well, that's what one would expect.
It's on them to produce evidence that would be the case, and that really doesn't appear here. And the last point on this, I think, is that the Common Solicitors and Counsel is actually very telling. because the fact that those lawyers are able to represent both of them, including in making submissions about what their relationship is, if there were in fact any conflict or disagreement between them, they wouldn't be in a position to do that.
Well, their interests need to be aligned.
Well, exactly.
Entirely, don't they?
Yes. But
So the relevance of those facts which I've just been through is in my submission twofold. First of all, it's relevant to this question of whether the prior conduct of dynamic in the litigation is a relevant factor which the judge could take into account. It's also relevant to the question of ability to comply, which I've started to touch on there. And I won't take you to Gama unless you would like me to.
But if you're only going to for the proposition that the burden is on the putative non-complier to show why they can't.
Yes, and I think
wouldn't have thought that was necessary.
Yes, the only other proposition I would take from it, and it's really by way of illustration, it's paragraphs 48 and 49, but is that the analysis there shows, as you would expect, that that is essentially a factual question.
Yeah.
Now, also on inability to comply, a point was taken about the Singapore.
Can I
freeze
just
law.
say this? I can't sit a minute beyond 4:15, and I'm not suggesting you'll be anything like that amount of time, but I just thought better tell you now than spring it on you at 4:05 when you've still got lots to say and Mr. McCulloch wants to reply. So if you can adjust your...
I will. I don't think I have very much more to cover.
No, fine.
On ability to comply, the other point that was taken was about the Singapore freezing order. The short answer to that is that one doesn't even need to apply to the Singapore court. It can be varied by the parties. So this is tab 20 of the supplemental bundle. Sorry, I've given you a wrong reference there. So it's tab 2 of the supplemental bundle. And it's on page 20.
Yeah.
So the defendant, which is dynamic, may agree with the solicitors for the plaintiff, that's my client, the spending limit should be increased or this order be varied in any other respect, but such agreement must be in writing.
Page 20.
Page 20, paragraph 6.
Yeah, thank you.
And we have, in fact, and unsurprisingly, already volunteered our consent to do exactly that. Which was explained in Yardley 8, paragraph 62, that the Singapore lawyers had actually produced a consent order.
And what about ETS, which had to be party too? I mean, they are now aligned with you broadly, but
yes,
but do we know what their position is?
Their position was that they supported the summary judgment application. The curator wants the shares back, so
Yeah, okay. It can be assumed that they would support.
yes.
Yeah, okay.
I wanted to deal briefly with the point that the arguments taken were not open because the prior breaches by Dynamic already existed at the time of joinder. And I say, first of all, that is misconceived as a matter of principle. But secondly, in fact, the position was expressly reserved, and it was very clear that we might seek conditions. So on the first of those points, straightforwardly, the long-term failure to remedy pre-existing breaches or failures to meet conditions clearly can be a reason or part of the reason for imposing a condition in December 2024, as the Deputy Judge did. And it's simply wrong, there's simply no basis to suggest that agreeing to the joinder of Xinbo meant that my client somehow waived any entitlement to complain or to take action against the prior breaches or the ongoing breach of Mr. Justice Knowles' order.
What about if, you may not accept it as a fair premise, a premise for part of the judge's order was the merits of the defence? Would you be, to put it another way, would you have been entitled to make a summary judgment application if there hadn't been any breach of the time limits?
Yes, we undoubtedly would have been entitled to make such an application. And going by the approach that Mr. Justice Bright took, and nothing factually has changed since then, except in our favour.
Well, sorry, I need a bit of help with that, because Mr. Justice Bright refused summary judgment.
Yes.
Was that a different sort of summary judgment that was being sought at that stage, so the one subsequently granted by Mr. Justice Knowles?
It was, and I think also we made it cross purposes, but yes, it was. So the summary judgment that was originally sought before Mr. Justice Bright was to be summary judgment on all of the claims, and that was because Dynamic and Ms. Chu had not said or done anything in the year since the proceedings had been issued and served. So we were applying for summary judgment on everything. And it was only after that application that was made that they popped up and said, we want to challenge jurisdiction, we want to defend, etc. And Mr. Justice Bright said, well, in circumstances where they want to defend, I think their defence is very weak, but I will permit them to do so.
Okay, so they hadn't become active when you put in your summary judgment.
Exactly. That was the original premise of the application. They then became active, and as he explains in his judgment, Ms. Provisa, who was leading me at that time, accepted that in those circumstances we couldn't press for summary judgment on all of the claims, but that conditions on their defending should be imposed, which is what he did.
Yes, in fact, the premise of my question perhaps wasn't the most helpful question, because you are in fact not saying that what you have done now is tantamount to a summary judgment application. You say it's the imposition of conditions, and we have now your answer as to why one of the conditions isn't equivalent to summary judgment. So in effect, what your application for conditions was effectively a sort of summary judgment light.
Yes.
Yeah.
Yes, and that was the question I think my Lord posed to Mr. McCulloch this morning, is, well, isn't this an order a judge could properly have made on a Rule 24 application?
Yes.
To which my submission is yes, he could.
Sorry, I think I interrupted my lady's train of thought.
Well, I think it comes to the same place. So after Mr. Justice Bright refused to give summary judgment, Mr. Justice Knowles did, but maybe in the terms summary judgment light. He did in the terms we saw earlier. But he did it in the context where he knew that that there wasn't going to be a defence from Dynamic.
Exactly, because the order of events was the condition had been imposed on Dynamic. So there could have been a defence, but Dynamic, or Xinbo standing behind it, refused to pay in the money.
Yeah.
So at that point, Dynamic is effectively debarred, it can't call witnesses,
Yes.
etc. So as regards the narrow claim against Dynamic for return of the shares, the judge is then satisfied that it has no real prospect
But
of success.
we've got a situation here where, as against Xinbo, we're certainly not yet in a position where there won't be a valid defence. So we're not in the same position as Dynamic. I think you need to rely on the fact, as you say it, that Mr. Justice Knowles made his order in the understanding that it would still be open to Xinbo to run its substantive case.
Indeed. That's exactly
In other words,
correct.
he was contemplating a situation where Xinbo would be able properly to defend the claim with a filed defence.
Indeed, but that is necessarily subject to the ability of the court to impose conditions on that or anything else in a normal way. And what was made clear at the time was that we might very well seek that conditions be imposed on Xinbo. So if one looks at Mr. Yardley's statement in response to the joinder application, so this is in the supplemental bundle at tab 8, page 67. Page 72, in particular. Paragraph 21.
Yeah.
And you see at the bottom of the page, GLAS is concerned to ensure people should not be prejudiced by delay, and also the named defence should not subvert the conditions imposed on the existing defendants.
But sorry, yes. You referred us also to 21, didn't you?
I did, yes. 21.
Sorry, no.
was
I
the
just for a
main
moment
point,
thought I'd
yes.
So
seen.
is the last part of 22 you were getting at then?
Yes, the last part of 22 was the dessert, as it were, and was to make the point, which is a point that we made before the judge, that Xinbo participating shouldn't subvert the conditions that had been imposed on the original defendants. The point being that where Mr. Justice Bright had concluded that their substantive defence was very weak and that they should only be entitled to advance it if they paid earnest money to do so, the defendants ought not to be able to get round that by Xinbo advancing exactly the same factual case, but saying it shouldn't be subject to a condition. Yes, I'm also referred to paragraph 17 of the statement, which says much the same.
Yes.
And the last point on that, and I'm afraid I don't have this in front of me, but I'm told that Zhang 4, which is the statement on joinder at paragraph 77, recognises the possibility of a conditions application, and as my scribbled note says, effectively says, we'll cross that bridge when we come to it.
We haven't got that because you don't think it's in the bundle, or because you just haven't got the
that's one
reference.
of
It's not in the bundle, it's one of the ones that I think you have been given.
Yes, I see, thank you.
I think there's a similar reference in the lawyer's witness statement.
Yes. So it was never the case, in other words, that Xinbo's coming in was represented any sort of recognition that it wouldn't be subject to conditions if it
Yes.
tried to run the
Yeah.
same
Yeah.
lousy
Now,
defence
Mr.
as the other.
McCulloch has made the point that that wasn't a point made to the judge. He says, in fact, the judge refers to the fact that there was unconditional joinder.
Which judge? I'm sorry.
The judge from which this appears.
The
deputy judge.
the deputy judge. Well, this.
So that's one of the points made against you, is that even if that might have been anticipated, that wasn't the way in which the code was put.
I would be surprised if that's right, because I hadn't understood that to be said against me. But
If you did.
I'm not.
I'm sorry.
I hadn't picked up that was quite how Mr. Houseman was putting it, but it may well be that
Not Mr. McCulloch.
it's Mr. McCulloch was putting it.
No, I hadn't either, because I mean, the witness statement that I've just shown you predates all of that, and is clear in saying that that we reserve that.
Well, there
right.
was. I think Mr. McCulloch did make a point about subverting. I think it was actually to be Mr. Justice Bright's order, which I suppose would be right. But I didn't think it was that point. I thought it was. I thought it was associated with his point that effectively you have been given the totality of the relief sought, which you have already answered.
By
I know,
explaining
not
that, yeah.
saying whether you've correctly answered it, but you've really answered it. But I didn't understand him to be saying that insofar as you were only asking for conditions, to do so was inconsistent with agreeing to the joinder order. But I don't
So
know.
the argument wasn't made below
Yes, I see.
on the part of your response.
Yes. Well, there we are.
So the lex specialis point I've not addressed, and then I need to say something briefly about the monetary claims which
Yes.
we touched on this morning. The lex specialis point in my submission just doesn't go anywhere as a freestanding submission. The order which the judge made is not an injunction, it's a condition. Xinbo has a choice. It can either pay the money into court and procure the return of the shares to the Luxembourg office holder, in which case it will be entitled to pursue its position before the English court, or it's entitled to choose not to do that. So it's not in any sense a mandatory injunction. It's simply a condition that says you have to comply to play. You have to ensure, as the judge put it, the dignity of the court is respected. Either its orders are complied with or it's not. And as I pointed out in the discussion with the judge at the hearing, and it was touched on this morning, a key difference in relation to a condition, or at least this condition, is that it can be varied. So unlike a final mandatory injunction, which would require something absolutely, this order makes provision that if it really isn't possible for Xinbo to comply with the condition, it can file written evidence explaining exactly why that is and invite the court to vary it. So the lex specialis mandatory injunction point doesn't go anywhere distinct. And then I think the last substantive point is the point that goes only to the monetary relief, and is this point that there was no pleaded claim to the monetary relief at the moment the proceedings came before the judge. And I deal with this at paragraph 54 and following of my skeleton.
That's your skeleton before us.
My skeleton before you. Yes, we spent most of our time with my skeleton below, but
Yeah, well, I found that helpful, but this one is for us. Yep.
and there are really the 2 points identified in paragraphs 55 and 56. So the first is that it wouldn't be correct in principle to say that the court can only require a payment in where there is a monetary claim against Xinbo, but that in any event it was obvious that one was coming. As to the first of those, it's necessary to consider what was actually the practical position in this litigation. The position that Xinbo advances by way of defence in Part 20 claim is to dispute the rights of the curator and thus ultimately other creditors in relation to shares which have an estimated market value of about 44 million euros. And as I note in the skeleton, the effect of the abduction of those shares and the delay in this case on the value of that asset has been severe. There's been roughly a 50% drop in the market price between the date of the transfer to Dynamic and the position as it was before the deputy judge. And it was that difference which was the essential basis for Mr. Justice Bright's very conservative, as he put it, assessment of the 18 million condition sum. That effectively that would be the potential damages arising because even when the shares are got back, they will be worth less than they would have been at the time when they were taken. And so the point about all of that is that the court is certainly entitled to say, if Xinbo wants to come and argue about a proprietary entitlement to 44 million worth of shares, which have dropped in value by a further similar amount, the court's entitled to say, well, it's a condition of you doing that you put up earnest money that would cover some very conservative pre-estimate of that loss. The second point is that it's an artificial point because this all arises only from the...
No, sorry, can I just understand why you say that? Is that got anything? Is that simply on the basis that if they were taken out of the company wrongfully, at the time they were worth 44 million, and by the time they are returned they're worth 22 million, you've got a claim for the diminution in value based upon the fact they shouldn't have been taken out in the first place?
Yes, those numbers are not quite right, but that's the principle, yes.
Sorry,
the 44 million is the residual value.
Oh, okay.
Their market value was higher.
You mean the market value when they were taken was higher?
Exactly.
So 44 is what they were when Mr. Justice Bright was making.
No, 44 I think is what they were worth before, well, at the time before the deputy judge. Mr. Justice Bright explains his number. So it's page 57 of the supplemental bundle.
Which particular paragraph?
131 and 132.
Yes.
Okay, so he's saying if he ignores the claim of loss in the value, which I can't assess, That's
Yes.
evidence suggests that a reasonable was outstanding claiming damages is 18 million. Sorry, well, if it's not the claim for loss in value of the shares, what is the claim for damages?
No, by loss in value of the shares, he means not the loss of not having the shares. The point is that there are pledged shares and unpledged shares here. So there are shares which are pledged to GLAS in any event, which have also suffered a loss in value as a result of all of this, because they've not been able to be sold as part of the majority stake.
So you're saying his reference to the loss in value is to the pledged shares, is it?
Yes.
Because I had misunderstood this as well. So you think the 18 million is an attempt to assess the fall in value of the unpledged shares?
Yes.
There isn't an additional claim you're making then, beyond?
Well, there is an additional claim in the proceedings, but he's not attributing any value to it in setting his conditions.
But that additional claim relates to the fall in value of the pledged
Exactly.
shares because
Yes.
you've split up a majority holding,
Exactly.
significant.
Yes.
Right, so you're saying, so just to recap, you're saying when judges have been considering to order a return of the shares have been worth in the region of 44
Yes.
million, and the diminution in value of those shares, the unpledged shares, during the time away from, you say their true owners, is about 18 million, or at least that's a conservative estimate.
Yes, that was
It's
Mr. Justice Bright's conservative estimate.
So it's of that order, okay.
Yes.
And that claim was, at the time though it was being discussed, a claim against Dynamic as the entity to whom the shares had been transferred,
Yes.
but as legal owner. And the basis for that claim against Xinbo at the time was not articulated, other than as a party to the conspiracy.
Exactly. So Xinbo was pleaded as a conspirator, as the court has seen looking at the pleading. And all that was required to be added were the small bits that you see in gold or yellow or mustard or whatever you want to call it in the most recent set of amendments, which effectively add a claim for a remedy in respect of that. I've actually found the numbers if it's helpful. They were in my skeleton below, tab 23, page 147.
I see at the top of the page.
Yes.
Yeah.
So before the deputy judge, the unpledged shares were worth 44 million. And then as paragraph C explains, that share price was just over half what the share price had been at the time of disposal. So they would have been closer to 80 million at the time of disposal. So the gap has in fact grown from what it was at the time of Mr. Justice Bright's very conservative estimate. So you looked at the pleading this morning and you saw the order of events where it came to pass via the consent order that Xinbo was joined, and the way it was going to work was that they were going to file a defence. But in my submission it was always clear from what you can see in the pleading that Xinbo, upon being joined, was going to be a defendant to the monetary claim. And one can see that also because it was identified in the evidence of Mr. Yardley, which is in the unagreed bundle at tab 13, page 96. Sorry.
Which paragraph? That can't be a right reference, then.
No, it's not a right reference. It might be the wrong bundle, I think. I'm sorry. Yes, it's the supplemental bundle.
Page
It
96.
is page 96, but I was in the wrong bundle.
Yep. So this is
So this is Mr. Yardley.
this is Yardley 8. Yep.
October 2024. So prior to the hearing before the deputy judge, and it's paragraph 11.
Are now made against it. Yep. So that's literally inaccurate in the sense that no such claim has yet been pleaded, but it's it states what the whole purpose, your purpose, in raising a read to the joinder is.
Exactly.
Yep.
Exactly. That's exactly it. And my final submission on that point. Well, sorry, two. First of all,
This evidence was in support of the conditions application.
exactly, yes. It's October 2024. One more reference to give you in Sigurdsson 1, which I think is one of the statements you've been given.
Yeah.
In paragraph 10, she lists what she understands to be the three issues involving Xinbo. And one of them, I'm instructed, is the question of whether Xinbo was part of the conspiracy.
Yeah.
And then the final point on this is that insofar as this court is reconsidering the order made by the judge essentially afresh, then it would clearly be properly open to you to take account of the fact that where that claim wasn't pleaded, it now is, and indeed was done so pretty promptly after that hearing. So,
and just to help me out, just before we leave this question on payment claim, I asked Mr. McCulloch to what he understood to be the basis for the judge's order of 10 million, looking at paragraphs 4 and 5 of the judgment. Was he effectively ordering it because there had been a default by Dynamic in complying with the order that had been made against Dynamic? Or was he ordering it, as it were, as a condition of Xinbo being able to defend and advance its own claim? Can you help? Do you understand? What do you understand him to be doing? Or do you understand the basis on which he actually justified that number?
well, setting aside for a moment that it's 10 rather than 9, in my submission, the two points that you identify there are actually really the same point, or at least very closely linked, because the 9 million condition on Dynamic is precisely because it's trying to advance this very weak defence which Mr. Justice Bright criticises and imposes the condition on it for that reason. So one can rationalise it either as saying, well, Dynamic has failed to comply with that condition, so Xinbo, as its principal, should do so as a justification for standing in the same shoes, effectively, as Dynamic. Or one can justify it on the alternative basis that Xinbo is seeking to advance the same substantive defence as Dynamic. That was a substantive defence which Mr. Justice Bright said that somebody should only be entitled to run if they pay that amount into court. And so Xinbo should have to do the same as Dynamic. And so either way, they come to the same point, which is that if you want to run this defence, you need to meet the monetary sum. As to the sum itself, my submission was, and ultimately still would be, that the sum should actually have been 18 rather than 9, because 18 was Mr. Justice Bright's very conservative estimate of the loss. He split that between Ms. Chew and Dynamic, but where Ms. Chew is gone, the judge in my submission would have been entitled to go to 18.
But that does link back to the question I just asked you, because then it does make a difference. Because if you're basically making Xinbo perform the order made against Dynamic, it's 9, not 18. If you're saying it's Xinbo afresh as a condition of defending a claim anticipated against it, then you might say 18.
Yes,
and that's why, in a sense, I was asking the question.
Well, indeed you might. The complication to that is that Mr. Justice Bright didn't accept my submission that it should be 18 joint and several first time round.
Yeah, but if the basis is Xinbo is being visited with the consequence of its nominee Dynamic not having paid the judgment, so satisfied the condition against it, then I understand why you arrive at 9. But you'd be hard pushed to go to 18 without effectively collaterally attacking Justice Bright's decision in that respect.
Yes, and there is no cross appeal in that regard.
So I think it probably has to be on the basis, the logical justification is that it's because of Dynamic's failure and Xinbo's connection with Dynamic's failure that Xinbo is required to produce the money, not because of any consideration of the claim against Xinbo in its own right.
I agree, save only that because the claim against Xinbo is essentially the same as the claim against Dynamic, it becomes almost impossible to...
I think you're denying that there's a real distinction.
I think I am, yes.
There is I see that. Yeah.
I'm sorry, I interrupted you before you were
about. Well, on that basis, and given that you say it should be 18, but you lost on that, and an element of an element in it, at least, is that this. Well, effectively, the basis is that Mr. Justice Bright said 9, and Dynamic didn't pay that. Why 10? Not 9.
Two possible reasons, neither of which is totally clearly articulated. One would, I suspect, be the passage of time and cost. But effectively, this has all happened. We were now almost a year after the Bright order. We'd gone from January to December. More cost, more time has been incurred. A second point would be the numbers that I just showed you suggest that actually a very conservative estimate by the time of December last year would have been more than 18 million. Significantly more indeed. And the third point is that I think what the judge is really saying when he says it's not 18 and not 9 is that it is a round figure, and he's taking the totality of everything into account and saying I'm going with 10.
Yes. And nobody seriously thinks that it is possible to have a genuine pre-estimate of exactly what in the sense, I suspect he was influenced, so he doesn't say, but it was just Mr. Justice Bright's approach. Well, this may be far too low, but it's enough to be in earnest.
Yes.
10 million sounds like you're in earnest.
Yes, and that really comes back to the purpose of the condition.
Yeah.
And although, and again, this is sort of why the question of pleaded claim against Xinbo is not really quite the point. Mr. Justice Bright used that very conservative estimate as a guide to where he should set the earnest money figure. But it's not ultimately a precise calculation. It's in discretion of the judge.
Yeah. Now, I see the time. We need to give Mr. McCulloch some time, not, I think, necessarily very much for a reply, but anything you haven't yet covered? I'm not aware of anything you haven't.
Not unless there's anything else.
Well, there may well be, my lord and my
has
lady
to
will
ask.
have some questions, but nothing else you want to say? No? Thank you very much. Mr. McCulloch, you don't no obligation to reply, but I expect you may wish to.
I'm grateful. Oh, Lord Malady, the first point regards the effect of the Knowles order, because as you've already seen, there are a number of curiosities about that order. First of all, it's very vague. It simply says summary judgment on.
Sorry, I can't hear what you're saying.
First
You're
of
looking at
all,
your screen.
the order is quite vague, as you've already seen.
Quite
It's
what?
Vague. It's not very precise. It simply says summary judgment in favour of the trustee on its claims against ETS and Dynamic. And you've already seen that part of the pleading talks about the prayer talks about the restoration to ETS's ownership. So it's not entirely clear to me from the order, or indeed from the pleading, that the distinction my friend draws is correct. And it's
Well,
also
you say it's not entirely clear it's correct. Are you saying it's wrong?
well, the position put forward by ETS before the hearing, and I'm going to have some difficulty here because there are two documents I want to refer to but are not before the court. In ETS's skeleton, and as I quoted during the hearing before Mr. Justice Knowles, ETS's position was that the shareholding ought to be, or the unpledged shares ought to be reunited with the rest of the shareholding in order that those shares could be sold as soon as possible. And ETS's rationale for that was that they would be more valuable if sold together as a majority stake, and the passage of time had led to a deterioration in value, and that's why the speedy sale of that package of shares together, reunited, was vital. And that was the approach of ETS to the summary judgment application before Mr. Justice Knowles. So ETS's stated intention in these proceedings is to sell the shares when it gets hold of the shares in order to avoid any further drop in the value of the same. So I'm not sure that one can accept the proposition that ETS is simply going to hold the shares subject to the dispute, which
Well,
is...
to be fair, I don't think Mr. Barden said that that's what the effect of the order was. He simply said the effect of the order would be retransferred. It'd be up to them what to do with it, but you wouldn't expect them as institutional court-appointed curator to take any legal risk.
Yes, but the point I'm making is that we go further than that to say that, well, actually what ETS have expressly said is that they intend to sell the shares.
And you say there's no evidence or assurance that your security or the right of ownership which you contend for, which I think, as Mr. Barden pointed out to us, was obtained via security, would either transfer to or would be protected in the event of a sale of the secured shares, that they would transfer either into the proceeds or as against ETS.
No, there's no evidence to that effect, and of course there's nothing which attaches to the condition.
But
They would-
nevertheless,
to preserve the shares. So
Justice Knowles' order stands unchallenged, doesn't it? There has been, I think there may have been an
Yeah.
attempt to appeal it, but it didn't succeed.
well, that's correct, Milady, and I see the point you're making. But the fact is that at the moment, the shares remain in the hands of Dynamic. They remain subject to freezing orders, and they're not going. And
but-
save insofar as Xinbo is compelled to try and procure that transfer, until that actually happens, they're not at risk.
Okay, but you can't escape the fact that its nominee is subject to an order of the court, an unchallenged order of the court. However unsatisfactory you think it is to transfer the shares.
Well, it is. It's subject to an order which was made against Dynamic, not an order made against Xinbo.
No, I said Dynamic.
Yes, Milady, that's correct. Xinbo itself simply seeks to avoid, in its own conduct of these proceedings, anything which would lead to it being frustrated in asserting its rights over those shares. And clearly,
I suppose it would be open to you in these proceedings, since ETS is a party, if the order was complied with, then to seek an undertaking from ETS not to part with them or to hold any proceeds on the same basis as the original security, and to ask for relief from the court if you don't get such an undertaking.
yes, I think that's certainly something that could be considered. And if Xinbo was of the view that those shares were going to be transferred, then that's certainly a step that it could take. But Xinbo itself,
Would need to give a cross undertaking
yes,
if there were an injunction.
if there were an injunction, yes, we would have to give a cross undertaking. Clearly. So the first point we make is that we don't think that we can blindly assume that the shares will simply remain in the hands of ETS and unsold, with our right of security preserved. As regards the issue of control in the proceedings, my friend mentioned the fact that this would be relevant where there were an application for third-party costs, and that's clearly correct. But it's not clear that this ought to be the basis of a decision, not just in respect of costs, but in respect of the procurement of the compliance with an order to transfer shares, and also with the condition, effectively the post-security, in respect of the potential damages against another party. So we don't accept that the issue of factual control, for which there is some passing evidence, although some of it does refer to the shareholding position rather than a matter of factual control, but we don't accept that that is the basis for an order in the terms that was made, or any order imposing a condition in respect of the shares, or a financial condition in respect of the other parties, namely Dynamic. Insofar as attention is drawn to the fleeting passage of time when Xinbo and Dynamic had the same solicitors, we would simply say that all that shows is that there was no conflict between the two parties. It doesn't actually show any more than that. It certainly
So
doesn't.
fleeting, I thought it was for some time.
I don't think it was. I shall
What
find
was the
out.
evidence?
I'll find out the exact period, but I don't believe it was for long at all, my lord.
Right. Well, keep going, so you haven't got much longer.
Yeah. As to Mr. Justice Bright's refusal to grant summary judgment, Mr. Justice Bright made a finding that there was a real prospect of success for the defence of Dynamic and Miss Q. It wasn't just that it was an inopportune moment to deal with a full-blooded
No, well,
summary judgment application.
Obviously, yes.
Yes. insofar as it said regarding the lex specialis argument that there is a choice, we would say that that's an unreal argument in that there's no real choice for a defendant and a claimant such as Xinbo, where the penalty will be not being able to defend the proceedings and not being able to pursue its interest in the shares. So the penalty, we say, is very severe in this case, if a penalty is imposed. And the reference to the possibility of varying an injunction, we say, doesn't go anywhere in this case, because of course the order of the judge below also provided for some kind of mechanism to come back and show evidence for inability to comply. So both orders function in a similar way. There was still the ability to come back. As to the reference in Mr. Yardley's evidence, which was before the judge, I would make the very simple point that it just wasn't referred to. The references to the claims being brought against Xinbo, which was just incorrect, that evidence was not canvassed before the judge, and the judge did not refer to it. So, yes, it was there, but it was not relied on. Although, unless I can be of any further assistance, those are mine.
No, thank you very much indeed. We will obviously be reserving our decision. When in due course draft judgments are circulated, they will be circulated on a confidential basis and for the specific and limited purposes identified in the Counsel General for Wales case, and they should only be circulated within the legal teams and the parties to parties who need to, persons who need to see them for that purpose and those purposes and no other purposes. And if there was any breach of that, it may well be a contempt of court. Thank you both to counsel from whom we've heard and from other members of the legal teams from whom we have not for the careful work that's gone into this case. We found the submissions helpful.